Always low prices at Pahrump Valley Auto Plaza.
In this week's court report, Shelby Maurice Thomas appears in district court for a probation violation hearing and has his probation revoked following being sentenced back in 2018 to 5 years probation for the charge of unlawful use of a controlled substance. Thomas has had a total of 3 probation violation hearings in district court connected to this case. And during his most recent proceeding, Thomas appeared while in custody along with his attorney, Nathan Gentry. Regarding his probation violation, the defendant admits the allegations against him, which include curfew violations. Thomas then addresses the court and states that he had phased up and returned, but came back late, according to staff. Parole and probation states that is not the case. PNB states that Thomas has 209 days credit for time served. Defense states where the defendant could live. The court then states maybe Thomas would be a candidate for a sober living home. PNP states that U-Turn for Christ has deemed that Thomas is not eligible for its program. Defense moves for probation. Then the court admonishes Thomas for his behavior in inpatient drug treatment and during probation. The state reviews the defendant's mental health record. Finally, the court revokes Thomas's probation and imposes the underlying sentence, 209 days credit for time served. The area man arrested on a sexual assault charge after a woman who moved in with him 2 weeks prior filed a report with NCSO regarding repeatedly violating their acknowledged sexual agreement with unwanted anal penetration. He appeared in district court without his desired representation after his case was bound over. Todd A. LaCour had a status check during which he appeared while in custody. A guilty plea agreement was submitted to the court. The state addresses the court and states that LaCour's pastor has an attorney who wants to take over the case. That pastor was present earlier during the day that morning of the proceeding, but was not there later, and the proposed attorney has not made an appearance. The court admonishes the defendant for his lack of faith in his court-appointed public defender, Brent Percival. Defense states that the issue may be that parties should have done an Alford plea. That's when a defendant in a criminal case does not admit guilt, but concedes that there is sufficient evidence to find him or her guilty at trial. That should have been done instead of a guilty plea, according to defense. Defense reviews in detail the negotiated maximum possible sentence versus the non-negotiated maximum sentence. Then the court admonishes LaCour for his indecisiveness with the plea. Finally, the state withdraws the current plea offer and court sets LaCour's trial dates for this October. This has been your court report. I'm Eunette Gentry for News 25.